Welcome this discussion. Basically, we shall be analyzing pre-law entry exam of 2010, and please we have coaching services. So in case you have you want a discussion group that issues notes, discusses all past papers, then you can please reach up on the number on our YouTube, or maybe then we are offering a mentorship program at an affordable cost. So pass the bar your legal mentorship hub. We are a group of 5 passionate advocates dedicated to simplifying the complicated for law students at every stage. We have pre-law exam for senior 6 leavers, undergraduate support, LDC mentorship at a monthly subscription, master's pre-law entry coaching, additional service in dissertations, research proposals, research projects, and research papers. I also have LDC pre-law entry mentorship. So in case you want our services, you can call us on or WhatsApp us on 0756767284. So this is pre-law entry exam of 2010. Define what you understand by the term common law systems. And of course, the common law system is a legal system developed from the English legal tradition based on judicial precedents. State 1 doctrine of equity. We have the doctrine of estoppel as applied in the case by Lord Denning in the London Trees Limited versus High Trees. What are courts of record? We look at Article 129 sub Article 2. We have Supreme Court, Court of Appeal, and High Court. Explain the meaning of the citation 1971 Weekly Law Report 725 at page 729. What is meant by the expression of painkarium? Painkarium means through lack of care. Explain the meaning of golden rule of statutory interpretation. We look at the case of Onyango Obo versus Anthony General and others, and also Tinyefuza versus Anthony General. The court explained golden rule and also literal rule. So the golden rule is an approach to interpreting statutes that modifies the literal rule to avoid absurdity. The Evidence Act is cited as Cap 8. What is the meaning of the citation? Cap 8 means Chapter 8. Distinguish between principal and subsidiary legislation. Principal is by Parliament. Subsidiary is by other bodies through delegation. Look at Article 79 of the Constitution. If an author makes a reference to EBD in a footnote, what does that mean? It means that the reference is the same source cited immediately before. What is the bar? Under the Advocates Act, when an advocate is enrolled, you are admitted to the bar. Section B, Constitutional Law. What is the Republican Constitution? A Republican Constitution is one in which sovereignty belongs to the people and the head of state is elected. So those ones who want this document, it's only available for students in our mentorship group. Those are the only one who can access this our revised work, because we have answered all past papers. Also, we have summarized notes. We have tests which we set and offer. We shall have a seminar. So as you can really understand, what's the Republican Constitution? The Republican Constitution is one which sovereignty belongs to the people and the head of state is elected. Look at Article 1 of the Constitution. Give one distinction between federalism and centralization. Federalism, sovereignty is divided between central and regional government. Decentralization, power is delegated by the central government, local government. Look at Articles 176 of the Constitutions. Define collective responsibility of Cabinet. Article 117 of the Constitution. Cabinet shall be collectively responsible for government policy and administration. What is the dual citizenship? Look at Article 12 sub Article 2 of the Constitution. And what circumstances can one become a dual citizen? For example, by marriage. Explain what you understand by present answer to the bill. Look at Article 91 of the Constitution. When the Parliament passes a bill, it's sent to the President for assent. State one remedy of a person who alleges that legislation is unconstitutional. Article 137, petition the Constitutional Court. We have a lot of cases. We have Susan Chugura versus Anthony General, Mfumi versus Anthony General. We have Lau versus Anthony General, Sihad versus Anthony General, among others. Name one right in the Constitution which is non-derogable. Article 44, freedom from torture, freedom from slavery or servitude, and the right to a fair hearing. How did the 1995 Constitution deal with the problem of an untitled occupants of land? Look at Article 237(8) of the Constitution. By granting security of occupancy, state the doctrine which is now generally accepted as an alternative, the strict separation of powers between the organs of the state, the doctrines of checks and balances. Organs of the state are separate but interdependent, each checking the other. 20. Outline the constitutional provisions meant to ensure the independence of the judiciary. Article 1281 of the Constitution. Also look at the judgment of Masaru Musene and others versus Anthony General. Section C, contracts. If offer and acceptance are made by email, where is the contract concluded? Look at Section 3, subsection 2. Agreement is made where acceptance is communicated. Look also the case of Enterprise Limited versus Miles Far East Corporation. The court stated that acceptance is effective when received. So you have to distinguish between the instant communication rule and the postal address rule. Why is it that as a general rule, a stranger, the contract cannot enforce it? Look at the doctrine of privity to a contract and the decision in Twindo versus Atkinson. So in case you want more discussions which are elaborate and in-depth discussion, please reach me the number on 0756767284 on WhatsApp. If you can pay the masters, if you can pay our mentorship fees, then we can put you in our discussion. But here we don't have a lot of time. That's why I'm trying to be as brief as I can, so as I don't take a lot of your time, but also I ensure that I deliver value. And remember, we have 100% guarantee, 100% guarantee in the way that if you're not happy with our services, we refund you 100% guarantee. We refund you 100% of your fees within 2 weeks. So we really trust what we do. We really trust what we do, and we give you 100% guarantee within 2 weeks. If you are not happy, and if you have not added any value to you within 2 weeks, then you will text back us and we shall refund you 100% of your mentorship fees. Name one relationship in which the law will presume and do influence the contract. Look at Section 13, subsection 12 of the Contracts Act, Cap 284, a lawyer and a client, a parent and a guardian, and also the decision in Alcad versus Skinner. Distinguish between void and voidable contracts. Look at Section 1 of the Contracts Act. Voidable contracts are not enforceable. Void contracts are illegal and not enforceable by law. Voidable contracts can be repudiated at the option of the affected party. Illustrate the meaning of an unilateral mistake. Look at Section 16, subsection 2, where both parties are mistaken. Look also at the case of Smith versus Hughes. Explain the meaning of restituto in integrum. Look at Section 60, subsection 3 of the Contracts Act, that any person injured by the failure to discharge is entitled to receive the same compensation from the party in default. What's the remedy of quantum merit? Look at Section 62 of the Contracts, and also the decision in the Monitor vs. KCCA, that the party who rightfully rescinds the contract is entitled to compensation for any damage. Will be put. Define what is meant by express terms of a contract. Section 9, subsection 2 of the Contracts. Contracts may be oral, written, or implied. Look at the decision in Estrange versus Grokobog, that a party is bound by his signature. Outline one rule governing exclusion clause. We have the control preferentum rule, that in case of any ambiguity in the exclusion clause, it must be interpreted against the person who incorporated it. Look at the decision in Sonstone versus Shulen Parking Company. The court stated that an exclusion clause must be brought to the attention of the party. State one way by which a contract can be discharged. Section 63 by frustration. We got the law of torts, Section D. What must the plaintiff who has been detained prove in court in order to succeed in that cause of action? Look at the decision basically Militia versus Red Paper 2017, that the statement was defamatory, that the statement referred the plaintiff, that the statement was published to a third party, and that it diminished the image of the plaintiff in the eyes of right-seeking member of the public. 32 John has erected a building on land belonging to Peter. What is Peter's cause of action? Trespass to land. Look at the decision in Justin Rutaya versus Steering Civil Engineering Company. The court stated that trespass occurs with wrongful and unauthorized entry onto another person's land. In your own words, explain the rule in Ryland versus Fletcher. A person who for his own purpose brings onto his own land and keeps there anything likely to do a mischief, if it escapes, is strictly liable for all damage that is for the natural consequence of its escape. You remember the facts in Ryland versus Fletcher were that this person had hired an independent contractor to basically build a reservoir. So after the reservoir had been constructed, the water escaped and damaged the properties of the neighbor. And the court held him liable that whoever brings something onto your land and it escapes and does a mischief to your neighbor, then you're liable. So you have to understand the rule in Ryland versus Fletcher, because it's a very potential area of examination as far as tort law is concerned. 34. What are the most important ingredients of the tort of negligence? We have the case of Donog versus Stevenson, most especially the judgment of Lord Attikins, duty of care, breach of duty, causation, and remoteness of damage. Bosco is the gardener of Mama Tina while mowing her lawn. A stone flew and broke a neighbor's window pane. On what principle would Mama Tina be liable for Bosco's acts? Vicarious liability. Look at the decision in Mutebe Ronald and another versus Omeme Uganda Limited, and also we have Limpus versus General Omnibus Company, but also we have the decision of Akech, Rosa Akech versus Anthony General, where her child has been murdered by police and he vicariously sued the government. Remember, he must prove that there was employment, he was acting in the course of employment, and he acted negligently. A driver of a motor vehicle tries to cross the rail line as a hooting train approaches. His motor vehicle is knocked by the train and is damaged beyond repair. What defense is available to the owner of the train? Voluntary non-fit injury of voluntary assumption of risk. We can see the decisions in Dan versus Hamilton. Civil Procedure Rules Section E. Name 4 types of orders that can be granted by the High Court in judicial review. Under Section 4 of the Judicature Act and the decision in Patterson Waga versus LDC, we have certiorari, prohibition, mandamus, declaration, and injunction. So in case you have any questions, you can type in the comment sections. We shall answer your questions or queries, or maybe in case you want us to explain anything, you can also post in the comment section, and then we shall answer. But also in case you want us to summarize all the past papers like this, please like this video and share to your friend. If this video gets enough views and a lot of shares, then we shall also summarize all the papers from 2010 up to I think the most recent, and it would be of good value to you. But if you, in case you want this document, you can only access this document if you are a member of our mentorship program. An infant must file a suit in court through look at Order 32 of the Civil Procedure Rules. He can sue through a next of friend. While in criminal cases, prosecution must prove a case beyond reasonable doubt. In civil suits, a plaintiff must prove the case on a balance of probabilities. Look at the decision in Miller versus Minister of Pensions, but also remember that in the case of Seburua versus Cooperative Bank, in fraud, it's slightly higher than the mere balance of probabilities. The following are the conditions which must exist before a court of law can grant temporary injunction to a litigant. Look at Order 41 of the Civil Procedure Rules, and also the decision in Chiimba Kagwa versus Haj Hassan Katende, one that there must be a prima facie case, the applicants will suffer irreparable injury, and there is a balance of convenience. Name 3 instances in which a review of judgment or order can be made by that by that High Court. Look at sections 82 of the Civil Procedure Act read together with Order 46. 1. Discovery of new and important matter, mistake or error apparent on the face of record, and any other sufficient reason. Look at the decision in FX Mobiru versus Nanteza of 1992. Procedure is by notice of motion supported by an affidavit in support. Identify the different ways through which a matter can be taken to the Constitutional Court. 1. We have Article 137 through a constitutional petition. We have a lot of those ones. Mfumi versus Anthony General, Sihad versus Anthony General, Susan Chugura versus Anthony General on death penalty. Mfumi was on bride price. Sihad was on maternal health. Ismail Serugo, I think, also was on maternal health. And then, among other decisions, not limited to Lau versus Anthony General or FIDA Uganda versus Anthony General. We also have a reference Article 137 sub Article 5. Look at the decision in Simon Chamanywa versus Uganda on corporal punishment. A defendant who is served with summons in a suit under procedure must take the following essential steps in court to safeguard his or her interest. Order 36 summary procedure. You have to seek leave to file a defense. You don't have an automatic right. Look at the decision in Post Bank versus Abdu Sozi. Law of evidence. Any written oral statement or communication conducted made by persons otherwise than in testimony of the proceedings in which it is offered is admissible if such statement or conduct is tendered either by proof of the assertion implicit therein. See the rule of evidence represented in that statement. This is the hearsay rule in section 59 of the Evidence Act, that evidence must be direct. And look at the decision in Subramaniam versus Public of the Prosecutor. Subramaniam versus Public Prosecutor. Briefly explain the rationale of the rule. Look at the case of Subramaniam versus Public Prosecutor. Hearsay excludes the maker of the statement cannot be cross-examined in court. It is not made under oath. There is a danger of fabrication, and the court must form an opinion on facts. State an exception to the rule. We have expert evidence or expert opinion under section 43. Still, section 59E talks about experts on any treaties, and section 59F talks about materials seen other than the document. Mention one situation where the exception will apply. Where the court requires specialized knowledge beyond ordinary persons. Examples: a medical doctor testifying on cause of death. Look at the Republic versus Sembatia. Also in Uganda versus Weransenga, where the inspector of motor vehicles testified on the conditions of the vehicle. A suspect in a murder case was tortured after arrest, as a result of which he confessed to a police constable. On the basis of that confession, the suspect led the police where the body of the deceased was found hidden in a thicket in a remote place. So here we are at confessions under Article 28(3) of the Constitution. Section 23 must be before the police above the rank of Assistant Inspector of Police. Section 24, confession must be voluntary. Look at the case of Uganda versus Tuamoi. And also look at Section 29 of the Evidence Act. Discovery of fact as a result of information from accused. Even if the confession is inadmissible, that part of the statement leading to discovery of fact is admissible under Section 29 of the Evidence Act. 47. Court is conducting a trial and accused for the offense of assault. The advocate representing the accused intends to call the accused employer testify that 5 years has known the accused as a peaceful and poised person. Here we are looking at basically character evidence. Look at Section 51. In criminal cases, the accused may adduce evidence of good character. Give situations when secondary evidence is admissible. Section 64 read together with Section 65 of the Evidence Act. When the original is in possession of the opposite party, when the original has been lost or destroyed, and when the original is of such nature as not to be easily movable. Criminal law, Section E. There are 4 categories of culpable mental states. Arrange them from the lowest to the highest. One, have criminal negligence. Under Section 210 of the Penal Code Act, recklessness. We have knowingly and intentionally under Section 174 of the Penal Code Act. Briefly explains the different circumstances in which a person can be found criminally liable for the acts of another. We have vicarious liability. Look at Akacho Rose vs. Anthony General. Common purpose or joint offenders. Look at Section 20 of the Penal Code Act. Principal offenders. Look at Section 19 of the Penal Code Act. Conspiracies. Look at section 263 and 364 of the Penal Code Act. Distinguish between the defense of insanity and that of diminishing responsibility. Insanity, look at section 11 of the Penal Code Act, is a complete defense based on the Magna Carta rules. Diminishing responsibility, look at section 177 of the Penal Code Act, cap 128. It reduces murder to manslaughter. Explain how you understand by the term incoherent offenses. Incoherent offenses are incomplete offenses, acts directed towards commission of a crime, so the crime itself is not completed. We have attempt, we have conspiracy and incitement. Mistake of a fact is a defense only if it, look at section 9 of the Penal Code Act. Mistake of a fact is recognized where it destroys the mens rea of the offense, so it negates an element of the crime. Criminal procedure. Offender has been charged with assault in the magistrate's courts. What grounds would he be released on bail? Look at Article 23(6) of the Constitution, read together with Section 75 of the Magistrates Courts Act and the decision in Chiza vs. Uganda, nature and wealth of the offense, likelihood of the accused attending trial, character, substantial surety, and fixed place of abode. Give 3 instances in which offenders may be tried together on the same charge sheet. Look at Section 19 and 20 of the Criminal Procedure Act on joint offenders, conspiracies, accomplices, among others. List all the different pleas available to an accused person. Look at the case of Adan vs. Republic, plea of not guilty, plea of guilty, plea of previous acquittal, plea of pardon, and plea of jurisdiction. The magistrate tried, convicted, and sentenced an accused person to 7 years imprisonment. The confidence insulted the magistrate, whereupon the magistrate increased the sentence. At that time, the magistrate was thanked as official after passing the sentence. Look at the decision in Uganda vs. Biaruhanga. So basically, that was the substantive part. Let us go to Aptitude. Basically, when I'm looking at the Aptitude, the secret is you have to apply comprehension. It's only comprehension. If you have understood how we read passages in literature, this is the same thing you apply in Aptitude. Only that here they give you legal stuff, but you only don't apply legal knowledge, but you strictly apply comprehension. So question 58, section 8 subsection 8 of the Advocates Act as amended lists persons eligible for entry of their names on the roll of advocates for Uganda as follows. The section applies to the person who is the holder of a degree obtained from university, and holds a qualification that would qualify him or her to be enrolled. So section 8 subsection 8 of the Advocates Act provides as follows. The correct answer is D. Only Ugandan citizens with foreign laws from recognized common law jurisdiction are eligible. So basically, this one you only apply comprehension, reading. Extract from Granville Williams, which of the following is accurate? Answer is C. A dissenting judge may still agree on certain issues but dissent on others. Head notes are useful but may be inaccurate. Question 60. Extract from Goa report on legal education. Which statement best captures Goa's argument? Answer is B. Goa emphasizes that law students should study law within its historical, social, economic, and political context. Question 61. Hadija annual leave entitlement. It was some simple maths there. Question 62. Zamunda visa fee scenario in which additional situation is analysis equally appropriate. Question answer is A. High parking fees discourage motorists, but the less revenue is collected. Same paradox as Zamunda. So basically here, you just apply comprehension. Like don't apply the law. Just read as if you're reading passages for literature purposes. That's the only secret of passing Aptitude, just like we did in passage reading. So section G values. Assuming you were an advocate instructed to represent terrorist suspects, would you represent them? Of course, under Article 28, it is the right of fair hearing. Article 28 3D, a person is entitled to the right of his choice. Article 23 subsection 3A provides for presumption of innocence. Roles of an advocate and regulations stop the advocate's professional conduct regulations. An advocate must do due diligence. In Uganda vs. Patricia Jangore, the court stated that an advocate shall avoid conflict of interest at all times. So I would represent the terrorists because first and foremost they are presumed innocent. They have a right to fair hearing, and representing terrorists doesn't mean condoning terrorism. It just means that they must be have a fair hearing, and if they are guilty, then they must be convicted. 64, give at least reasons why you would like to pursue the bar course. These are reasons are personal. First and foremost, even this section above was personal. You can say yes or no, but still you'd have to rely on the law. Don't write as if you're a social scientist student. Give at least reasons why you would like to pursue the bar course: to fulfill the constitutional mandate of access to justice, Article 28 of the Constitution, to join the noble profession of advocates under the Advocates Act. Section 1 of the Advocates Act defines an advocate to mean any person whose name is duly entered upon the roll, acquire practical legal skills for service to society. Section 16 of the Advocates Act, for one to be eligible to apply for enrollment, must have obtained a diploma in legal practice, serve justice with integrity and compassion, beyond professional recognition, and pursuing the bar course out of deep conviction that justice must not remain an abstract promise. I want to become a voice for the voiceless, a defender for constitutionalism, and an agent of social transformation. So basically that was it for 2010 LDC pre-entry exams. In case you have liked this video, please like, comment, and share to your friends. So if this video gets many views, we shall make videos on all the past papers of LDC pre-entry exams. And in case you want a detailed discussion, please WhatsApp me on 075 6767 so as you can join our discussion groups where students pay 150,000 up to the date of the exam. We shall have a seminar, we shall have tests, basically to equip us for the preparation for the final exam. Please like, share, comment, and don't forget to subscribe. I will remain the Pass the Bar team. This document is only available to our students, so we don't share it, but please, we wish you success in your exams.